Your Honour, if it pleases the court, my name is Tierney, Tierney, initials JA. I appear on behalf of my client, Miss Lynn Barco, who has changed her plea from guilty to not guilty, pursuant to Section 590, capital A, capital A. My client is currently charged with 5 counts of breaking and entering a premises and committing an indictable offence under Section 421 of the Criminal Code and 1 count of attempted arson. Your Honour, I am seeking to exclude the admissions that were obtained during the questioning of my client. I submit for your consideration that these admissions were illegally and improperly obtained in contravention of the Police Powers and Responsibilities Act 2000 and the Police Powers and Responsibilities Regulations 2012. Your Honour, can I seek the indulgence of the court and dispense with full legislative citations and refer to the Police Powers and Responsibilities Act 2000 as the PPRA and the Police Powers and Responsibilities Regulations 2012 as the PPRR? Thank you. Your Honour, the contraventions of the PPRA and the PPRR are grounds for excluding the evidence of my client's admissions under the fairness or Christie discretion, as well as under the public policy or island discretion. Your Honour, I will firstly outline why I believe that the fairness discretion should be applied to exclude my client's admissions from evidence. It must first be decided whether the evidence against my client has a high probative value. If the court were only to look at the recording, then yes, it does. However, it would be unfair to include the admissions made by my client for several reasons. Firstly, the police officers never advised my client of her right to silence as is required under Section 24 of Schedule 9 of the PPRR, which is also reinforced by Petty and the Queen. It was not fair on my client that she was not advised of such a fundamental right. Secondly, the police officers did not identify that my client was gratuitously concurring with every question they asked. The police officers did not take the requisite steps that officers did in the Crown and Sailor to determine whether my client actually understood the questions being asked of her, and as is best practice when questioning a person of Aboriginal or Torres Strait Islander descent. Upon consideration of how the admissions were obtained, the probative value of the evidence in my client's admissions has drastically decreased, Your Honour. In applying the test from Hasler, the prejudicial effect of submitting such tainted evidence significantly outweighs the diminished probative value of any admissions. The defence submits that my client's admissions be excluded from evidence under the fairness discretion. Your Honour, moving on to the public policy discretion, the defence submits that applying the test from Bunning and Cross to my client's admissions will highlight the conduct of police when questioning my client was illegal, and therefore any evidence obtained during that time should be excluded under the public policy discretion. The 5-question test from Bunning and Cross that affirms my reasoning is as follows. Firstly, whether or not the police have deliberately disregarded the law. On the facts, it does not appear deliberate. Rather, the police officers have been reckless in not following statutory procedures of advising my client of her right to silence, again as required under Section 24 of Schedule 9 of the PPRR, nor did they follow the proper procedures for questioning a child as is required under Section 421 of the PPRA. Secondly, whether or not the illegality resulted in the evidence obtained being less reliable. Well, yes, the evidence obtained through the contravention of the PPRA and the PPRR does result in the evidence being less reliable because the proper statutory procedures were not followed. Thirdly, how easy would it have been for the police to have complied with the law in the circumstances? Your Honour, it would have been relatively easy for the police to have complied with the law given the circumstances. Firstly, prior to commencing questioning of my client, all the police officers had to do were advise her of her right to silence. Secondly, once they once they took my client to the police station, all they had to do was ask her who she wanted to contact as her support person. Instead, the police officers tended to cut corners and advise my client who her support person was going to be, a white middle-aged social worker who subsequently advised my client to answer any questions the police asked. Fourthly, what is the nature of the offence? Well, the charges there are 5 counts of breaking and entering a premises and committing an indictable offence, and 1 count of attempted arson, which is not as serious as other offences. And finally, what is the manner in which the legislature appear to have sought to restrict or control police actions? The purpose of the PPRA, specifically Section 7, is to prevent this sort of conduct by police officers who should be well versed in how to question a suspect, particularly a child suspect. After consideration of all the factors, I would implore Your Honour to exclude my client's admissions on the basis that it is not in the interests of the public to encourage police officers to break the law. Your Honour, I cite the Crown and Day, the Crown and Casey, and the Crown and Bly as authorities to support my argument that my client's admissions should be excluded from evidence. To conclude, if Your Honour so decides to exclude the evidence based upon the fairness and or the public policy discretions, then the defence would ask Your Honour to dismiss the charges against my client and that she also be released from custody. Thank you. As Your Honour pleases.